The Supreme Court has directed Jaiprakash Associates or JAL, the parent company of Jaypee Infra JIL, to deposit 1,000 crore rupees by June 15 for refunding to home buyers. The Apex Court has also barred any move to initiate liquidation proceedings against Jaypee Infra after its insolvency resolution fell through. Welcome to Urban Reality. I'm Anisha Natarajan, and today we have a fairly simple, straightforward show. What comes next after the stay on liquidation of Jaypee Infra? And these are the three questions we are asking. Our first question, what best can the Supreme Court do for the still stuck 20,000 home buyers? The second question, what is the optimum outcome that bank lenders can hope for, considering they do need to recover almost 10,000 crores of delinquent JIL loans? And our final question, are the interests of the bank lenders and home buyers completely at odds with each other? Or is there a meeting ground where both can lose the least and win the most? Joining me today for this debate, Alok Dhir, Managing Partner, Dhir & Dhir Associates, Abhishek Dubey, Corporate Lawyer. Also with us, Chitra Sharma, JP Home Buyer, initiator of Chitra Sharma versus JP PIL for all home buyers pan-India against builders and IBC 2016. And Rajen Chitale, Managing Partner of Chitle & Co. Gentlemen and Chitra, thank you very much for joining me today. I think this is a very interesting case because it will probably also go down in history as precedents to what can come for most of these cases. I mean, it's not the end yet when it comes to real estate companies going into insolvency. So I'm going to just start asking you the very first question because it's been a very long battle for you. What is it that you're hoping Supreme Court is now going to do? Manisha, or the best outcome?
Yeah, Manisha, thank you for having me over here. And the only thing I can put forth as a common person or a common citizen of India is that, we are simple home buyers and nothing beyond that. And we have paid our money. IBC, whatever, all these liquidation proceedings that have been initiated against JIL, that is a law which has been born in 2016, I guess.
Yes.
And we have, invested or bought our flats way back in 2009. So I think, and personally, all the home buyers feel we should all be kept out of the ambit of anything to do with IBC.
All right.
2016.
Okay.
Because we have bought our flats at a time when this is not even existence.
Your big fight is why even drag home buyers within the IBC ambit. Okay, Alok, I know that everybody is sympathetic to the home buyers' plight. Look at it. I mean, when I go out and meet them and I hear the stories, if you're paying EMI and rent for the last 10 years, there are people who come to me and say, we have still not been able to graduate from a scooter to a car simply because, because of this double whammy, the anguish, all of that. Put that aside and say, what is the best outcome for the home buyers?
Thank you, Manisha.
Let's not go to the bankers and lenders yet. I'm just asking you to wear the hat of the home buyers' anguish and tell us what can be the best case outcome for them.
Let me tell you very interestingly, all of us citizens of the country are home buyers at one time or the other.
Absolutely.
So it affects all of us. And however, I would say that the insolvency is a very complex issue. When a company goes down, it is very difficult to say that one part of the company or one stakeholder must be treated independently of the ongoing liquidation or ongoing insolvency of the whole company. We have to balance the rights and the reality at the same time. There are other stakeholders. The home buyers are there. There is the banks who have also given loans. There are the workers. There are the employees. There are creditors, operational creditors. So there's a lot of people, and the interests of all of them have to be balanced. Needless to say, the home buyers have put in their money, and it's a very emotional issue, and it's an issue which, it is sympathetic. Look at the Supreme Court. It has, under Article 142, to do complete justice to everybody, has standing as a shield and given its own cloak of protection to the home buyers. They've gone to the extent of saying that we are going to override the provisions of the IBC, and I dare say some other laws, to ensure that the protection to the home buyers is given and they're given their due right. But at the same time, when reality will sink in, when this insolvency will have to be decided, the interests of other stakeholders cannot be brushed aside altogether.
All right. So that's your position, that you cannot take the home buyers outside of the insolvency proceedings. Abhishek Dubey, come in here. You're wearing the hat of a home buyer as well as a lawyer. Would you be on the side of Chitra or would you side with Alok?
See, I believe there has to be a meeting ground and there can be a meeting ground. Now, this case highlights the importance on why home buyers should be classified as financial creditors. Now, the IBC committee squarely said that under the present definition of financial creditors, home buyers already are financial creditors, but to avoid any ambiguity, they recommended that the IBC code be amended and home buyers category should be included as financial creditors. So see why there was no resolution found within 270 days is also because none of the home buyers were able to vote on that committee, and home buyers have paid around 15,000 crores to Jaypee Infratech as opposed to around 9,500 crores by the lenders, by the banks. So banks want to take it to liquidation probably because it will fetch more value for them if the company goes to liquidation. However, if the home buyers were to be there in the committee of creditors and if they were given their lawful right as financial creditors, there might have been a resolution within this period of 270 days. Now, Supreme Court started this petition in September, and we are already, completing 300 days from there, and home buyers have still not got
don't
anything.
have a resolution.
They are still
All right,
at the same position. They are still at the same position which they were in 2009.
All right. Okay. Very important point noted and made. Mr. Chitale, come in here. That, this IBC is already, the committee is already discussed making a change in the code or in the laws to make home buyers financial creditors. How long does it take to take that kind of a step? Because, this entire resolution process, as Abhishek Dubey has put in, would have probably come to its natural conclusion if home buyers also were represented and had the voting rights.
I think making the change in law is a subset of a larger framework of the recommendations of the committee which are already in place. It can happen any time if it is done through an ordinance. But this is not the only change which will happen whenever it happens. It will come with a host of other changes. Having said that, I think the situation of home buyers versus the lenders will have to be balanced. At the same time, when you actually come to implementation of, irrespective of what finally happens, is even for the lenders to actually have any optimum realization, whether by taking away the security or otherwise, would necessarily have to recognize the rights which have been created of the flat owners in those sale proceeds, particularly where the flat owners would have borrowed and they would have received an NOC for their lenders from the lenders who have got the mortgage of the land.
Okay, fair enough. So let me come to the next question, and let me start with Chitra again. So Chitra, my second question to you is, if you do not want the Jaypee management back, which is something which has been made very clear by all the home buyers, we do not want the management back, we do not trust them, then you have to go with someone else. In that case, would it be okay with the highest bidder coming back? What are the guarantees or warranties you would like Supreme Court to oversee on behalf of home buyers?
Manisha, yes. 3 of them have been asked to rebid. That is Uday Kotak with Cube, I guess, and Adani and Suraksha. And since it's again our interest involved, credentials and their ability and what you call is their credibility in the market should also be taken care of. And
you believe there's a difference in their credibility?
Absolutely.
Okay, all right. We will get back to the resolution specialist, insolvency specialist. And but go ahead.
Secondly,
why do you sense that?
Because, I don't want to name anybody, but there are certain names like if you take name is more than enough.
Okay, so you're saying that do not just take the highest bid as the one which goes through, but go ahead and also take cognizance of how much experience do the bidders have.
Yes, in the field it is.
Okay, because what else do you want as a warranty? Because even in the bidding resolution plan which has come, I think none of the bidders spoke about any penalties to the home buyers. They only talked about completing the homes in a period of 5 years.
Yes. First and foremost, how can there be a blanket that we will not hand over any project before 5 years or 3 years? It has been noted that different projects are at different stages.
Okay.
How can you say that a project which is 85% complete, I have paid 85%, right? And 15% I have not been able to give, Because
Okay, point taken. So it's a blanket cover which is
Yes.
bothering you. All right, what about penalty? Now,
Yes,
this is my other
penalty.
big quibble, and let me ask Abhishek Dubey this. This is something, Abhishek, you and I, since the time that we've been doing every special on JP Infra and the home buyers, I have always asked you, look, in this scenario, everybody is taking a haircut. And when it comes to home buyers, the penalty interest demand perhaps might be reasonable because of the anguish, financial anguish that the home buyers have seen. But is it possible in a scenario when everybody needs to take a haircut? Your point.
Yeah, so see, what we have seen so far is that NCDRC and Supreme Court have, in these kind of distress cases, for example, Unitech and Supertech, have awarded penalties. Now, there can be a reasonable haircut on the penalties. So, for example, in some cases, they have given 14 to 12%. Maybe in the JP case, it may be a little lesser, but there has to be some form of penalty, because otherwise, it will, then set a precedent that any builder will basically raise money, not deliver for the next 10 years, and in the end will give a haircut, or give just the principal back. So now, if home buyers look at it from the perspective of home buyers as well. So, for example, if I have taken an apartment of 50 lakhs for which I have taken a 50 lakh loan, I have to pay at least 90 lakhs in a period of 15 to 20 years to the home finance company. So if I am given only the principal back after 10 years, which is which is the time now, so I'll have to only pay whatever amount to the bank. I will not be left with anything else. So it's a negative situation, net negative for the home buyers.
It's actually a huge capital loss. I know you're not putting a figure to it, but if I were to just open a spreadsheet and do a 20-year loan, the home hasn't come to me for 15 years and I've been paying EMI and interest, I would probably pay more than double of the cost of the house, if not at the least. All right, point well taken, but let me get a quick reaction from Alok. Alok, what do you suggest? In this case,
firstly, I'd like to react to one issue about the three bidders and something that Chitra said, that they just don't want to look at JL. That, in my mind, is not the way a liquidation works.
They do not want to look at?
JL, JIL, JL, the existing JP group, if I may say
JP
so.
group, all right.
Now, to my mind, a liquidation, when an insolvency or a liquidation is about, you can't throw anybody out of the system because you don't know.
They're barred by Section 29 under IBC. So let's not revisit that part of it.
Let me again let me remind you, this whole process is being looked at by the Supreme Court under Article 142. They have very clearly said that we are willing to override the provisions of IBC. So you can't be selective. I'm in any case not saying that bring them back, but I'm saying any approach to insolvency from a commercial insolvency standpoint, saying that I want this person out of the system, I'm sorry to say, is not a correct approach. We do not know at the end of it whether they will come forward as the best bidder or they will fall by the wayside and some third party will come. But I'm opposed to an approach which says I don't want to look at one stakeholder. They are a stakeholder. They may have done wrong. They have certainly not fulfilled their commitments, and they, to the extent the law permits, they will be penalized for it, and they should be penalized for it. But the question here is that we are looking at a situation saying we don't even want them in the system, yet we want money from them.
What else is your quibble?
The second issue, I don't have a quibble. I personally feel that when we are looking at a great damage to the system, when we say that we want to stand out, irrespective of what our rights are, just because we have been wronged. Certainly they have been wronged. Certainly they are entitled to say.
Point made.
So just because they are wrong does not mean that every other stakeholder and all laws of the land should not apply to them. So we have to work in the system.
Right now we are only talking about it is still IBC and Section 29 still bars them for a particular reason.
No, I'm sorry, it is not. Nothing that is being done is IBC. The money that 750 or the money of 2,000 crores which is being asked for is not a part of IBC. You are on the one side saying 29A, I don't want you in. But you are saying bring in this money. This money could have been brought in, according to me, if there was a money which has been transferred from JIL to JL. So please bring the money back.
Okay.
Under what basis are we getting? If we are getting this money under Article 142, the Supreme Court is looking at protecting the interest of the shareholders, you can't say then 29A doesn't apply. But be that as it may, it is the three judges, the Supreme Court, who will decide the issue. The concern in my mind is that we are all looking at this issue with a very myopic view. We are flat buyers. We are in trouble. We have paid our monies. We're not getting our homes by. That's a myopic view. You have to broaden your viewpoint. You have to first have an end game in your hand. You can't just say that we are relying upon the wisdom of the Supreme Court to do something. In fact, if I may say that, Supreme Court in the first order of 4th September directed the resolution professional to prepare a resolution plan, which has not come. The resolution plan could have said that here is money which is going to come from a third-party investor. Here is money which should be contributed for whatever wrong that JIL or JIL has done. But that must be a civil wrong. We have to understand. If there is criminality, if they have done fraud, they must be...
And the resolution professional. Okay, all right. I do have to get Mr. Chitale's, but so if you have a quick point to make, then
Nothing.
I can.
I'm merely saying that if there is a fraud, he must be put to it. If it's a civil wrong, if there's a civil injustice which is done to them, it must go by the civil laws.
All right. Well, the criminality of the case.
Can I just say one?
I'll come back to you, Chitra. Unfortunately, we need to take a very quick break. I mean, this is a very big issue in terms of opening up a whole Pandora's box on discussing whether the management itself should be given room to be brought back. Because after all, the legal implications of this case are so high that similar NCLT cases involving home buyers are likely to come back. And, you know, what the Jaypee Infra case has as an outcome is going to become a precedence for several others. So we're going to come back and carry on this discussion on what's the best case outcome for both the home buyers and the lenders.